Good morning, Ms. Combs.
Good morning.
I see you brought some cheering section, so why don't you introduce it to us?
Yes, one to my surprise, my husband, Tom Swartwood, is here, and Jesse Linebaugh, one of my partners, has joined me.
Okay. We appreciate you putting your application in, and we're ready for your opening remarks.
Thank you. Thank you, all of you, for giving me the opportunity to appear before you today and for your work on this commission. I know that my application indicates and conveys that I have worked in big cities and for a big law firm, but I want you to understand that I'm not from a big city. I am the first in my family to become a lawyer, and I was born and raised in Joplin, Missouri, which, for those of you who don't know, is a small town in the southwest corner close to Oklahoma and Kansas. I'm the second of 4 children. My father was one of 10 children, and he was a geologist for the state of Missouri Highway Department. He grew up on a farm in West Plains, Missouri, which he lost during the Depression for, I think, $300, if I remember correctly what the amount was due to the bank. He fought in World War II, and when he returned, he went to college, and he was the first one of 10 children in his family to graduate from college, and he went on to get a master's degree at the University of Missouri. He had an ag degree, and his master's was in education. And he started out teaching ag in a very small community college, which I don't think exists anymore, in Iberia, Missouri, and then ultimately moved to Joplin. So he was an ag teacher there and then became a geologist. So he served on school boards in Joplin and ultimately on the state board, school board, ultimately. So education was always a very important part of our lives. My mother was a musician. She was a piano teacher, and she taught piano out of our house. She also was the church organist and the choir director. So music was also very important in our family. So we all played an instrument, and we all sang in the choir, and that was a requirement. We grew up on an acreage outside of Joplin. We had horses, 2 Angus cows every year, a goat, sometimes a chicken, and cats and dogs. And I rode horses in a mounted drill team, and we rode around, went around traveling, my sister and I, with my parents, to rodeos in the summers, to in small towns, to appear at our mounted drill team, to appear in them. I also learned how to sew. I attended college at Southwest Missouri State, which is now called Missouri State University, and I went there to be a music major and study piano. But I decided while I was there that I really wanted to be a lawyer. I wasn't quite sure what that entailed because I didn't have one in my family, but I started taking political science classes. I had a teacher who was wonderful, who encouraged me to try hard. I got an internship in Washington for a congressman from Southwest Missouri. And while I was an intern in Washington, the legislative assistant to that congressman, I learned that he had gone to Georgetown Law, and I thought he was a very smart man, and I liked him, so I applied to Georgetown, and this professor encouraged me to do that, and to my surprise, I got in. So I went. I met my now husband, Tom, on the first day of law school in Georgetown, and he was from the New York, New Jersey area. After law school, I had the opportunity to apply for a clerkship with Judge Bright on the 8th Circuit Court of Appeals, and I moved to Fargo, North Dakota, where Judge Bright, that's what you do. You live wherever the judge lives, and then you travel 1 week of each month for court week with the judge. So I lived in Fargo for that period of time in my clerkship. It was a very profound experience and one that stayed with me forever. I had some amazing experiences. Judge Bright was just as, if any of you knew him, was a dynamic person. He was just larger than life, I think is the only thing I can really describe him as. He had a rule that if you disagreed with him about how he was going to rule on a case, you needed to come back and argue with him about it at least 3 times. He gave you, when you started, his expectation of the writing style that he wanted all of his clerks to use, and it was an active writing style that was fairly plain, and it was great advice and something that I've utilized ever since. During that period of time, the farm crisis was occurring. There was a toxic shock syndrome case, which I remember helping write the decision on, Tom Riley handled out of Cedar Rapids. There was a very large case involving a Sioux tribe election dispute, and I also, Judge Bright became friends with Justice Rehnquist on the Supreme Court, and they did jurist in residence programs, and I was lucky enough to get to drive them around St. Louis one time. So he had this ability to get along with other judges, even if they were sometimes on the other side of the aisle or on a decision, and I think that was something that was really affected me. And Judge Ross from Omaha, and he were often not necessarily in agreement, but they were always friends. After my clerkship, I had an offer to go to Washington, D.C. to join the honors program for the Department of Justice appellate program. But at that point, I had been in Fargo. Tom was in New York at that point, and was, I believe at that point, then working in the investment area. And to go to Washington would have been another 3-year commitment. So instead, I agreed to go to New York so that we could be together. We ultimately married, had 2 children. I practiced in private practice, made partner, but at that point really wanted to go back to the Midwest, somewhere where we could raise our kids outside of Manhattan. Tom actually is the one who got an opportunity to come to Des Moines, and that was close to Missouri, and I didn't really know much else about Des Moines, but agreed, you know, that was great, let's go. And so we moved here in 1994, the year after the Great Flood, and we have been here for the past 24 years. We've raised our kids here, our home is here, our jobs and our community, and it's very much our home. My law practice has been primarily commercial and business, as you, I'm sure, can tell from my application. I've had jury trials in both federal and state court all over the country. The application asked for in the last 2 years. In addition to the ones on my application, I tried a case in downtown Los Angeles State Court. I also was second chair on a case that came up before the Iowa Supreme Court called the Schlegel case, which was a two-week trial in Ottumwa. I remember having to walk across the street to the Maid-Rite to try to get a witness to talk to us during that particular jury trial, and it ultimately came on appeal. I've had many cases in Iowa state courts in addition to federal courts. I can think of hearings that I've had in Dubuque, Davenport, Cedar Rapids, Fort Dodge, and Sioux City, to name those that I can remember. And all of the cases that I've worked on have had a myriad of state law claims, whether or not they were, you know, in federal court based on diversity jurisdiction or in state court. Those included breach of contract fraud, negligence, tortious interference with contractual relations, defamation, deceptive trade practices, and administrative review of agency decisions. For lots of clients, in addition to the financial services one, which seemed to dominate my application, also agricultural, construction companies, and entertainment companies. I've also done, at least that I can think of, over 10 arbitrations that we tried to an ultimate result before arbitrators, and I've appeared before regulatory agencies and argued Administrative Procedure Act. That included both state agencies and federal. I have loved being a lawyer, and I still love it. In addition to practice as a lawyer, I also have experience in management and as a firm leader at my firm, which is over 750 lawyers. We have a management board that's made up of 13 members, and they are chosen by a nominating committee, and I'm serving now my 2nd term, which is going to end in a few months. We manage a budget that is in, I think, the hundreds of millions. And during my tenure, there were 2 large firms, Faegre and Benson and Baker Daniels, which merged. So I came on the board right when that happened, and kind of witnessed from the Des Moines angle 2 large factions attempting to work their way together and get along. And there were some really good lessons, I think, for me in that, about the importance of building consensus and working together, because tomorrow you're going to have another, you know, issue that you're going to have to work on. As far as what methodology that I would hope to apply as a judge, I think it would be the same one that I have used for 35 years in practice since I was a law clerk. Don't decide a case until at the beginning. Wait until you know all of the facts, the record, what's in it, what does the statute say, what is the case law that's out there, and get an understanding of the entire universe of what you have to work with. I've always done that, and I think colleagues of mine that have worked with me know that I want to see the cases themselves. I don't, even if we have a large team, I still, and maybe to my detriment, want to read it myself. I'm fairly analytical in that respect. Try to apply your principles objectively, and try to be consistent with analogous cases. It's important so that you have credibility with the decisions that you're making. As many of my colleagues know, I've wanted to and thought about serving on the court for many years. When this application opportunity came up, a number of people really encouraged me to apply, so that's why I'm doing it. I feel like I'm at a point in my life when this would fit well for me, and I would be able to, if asked to serve, devote my all to it. Thank you. If you have any questions.
Thank you, Ms. Combs. Why don't we start with Mr. Gray? Take a microphone, Mr. Gray, please.
Ms. Combs, it appears to me when you try lawsuits, you have lots of resources that you can draw upon. Many of the folks who practice in Iowa are in small firms. Can you assure me in some way you have empathy for those folks who don't have the resources that you're accustomed to when you look at how they try lawsuits?
I can assure you. Even in a large firm, there are many times when you really wish there was another you somewhere to handle whatever it is you have to handle. And I fully recognize that, and sometimes envy small town practitioners who are a little bit, can make their own decisions. They may be able to handle their cases in a way that we used to be able to do a little bit more than we can sometimes in practice. But I recognize fully sometimes in big law, if you will, maybe we overthink an issue. We have the resources, as you say, sometimes to delve into every single issue. And a small town lawyer, their client can't afford that, and sometimes it's not necessary. Sometimes what we do is really dig into the weeds deeply, but then in order to really present our case, we have to come back up to the 10,000-foot level. So really get to the issues that are going to matter and help you win your case. So I would hope that I could relate to them.
Thank you.
Mr. Harbaugh?
Thank you. I am one of the lay persons on the committee, and so I don't know if the others struggle like I do, but I only know one person of the 22 original candidates. And so we have to seek advice from people we trust in the lay world, and to a T, not most of them, every one of them, when I asked about you, they said, she is super smart. And that's where they ended, super smart. So I would like to know, what is your second greatest attribute?
I would say they're wrong. I have never thought I was super smart. I think I work hard. I have notes with me here today. I have watched people come in here. I tried cases with people, a particular attorney I'm thinking of, who can get up and talk for 2 hours without looking at anything. I can't do that. I'm going to work harder, and that's why I'm saying I'm going to read all the cases, and I'm going to be prepared. And I can still ride horses.
Thank you.
Ms. O'Brien?
Thank you. Ms. Combs, would you please talk a little bit about your experience on the management committee of your firm and how you think that would help avoid some of the tribalism, nativism, whatever word we're using this week, that occurs when you have a sharp division along philosophical lines?
Sure. I think the two firms that merged were roughly equal in size. They both had big offices that were the mothership. One was in Minneapolis and one was in Indianapolis, but they wanted something better and bigger, and they recognize that in big law there is a push to merge. So they had a common goal, but many of the people from those two firms were used to being, everything was run from their mothership, so they had to learn how to, we set compensation for all of the partners, so we had to, slide them into each other, and there was tension, absolutely, with respect to that. Tribalism is funny that you use that word, because I may have told you, I had a partner on the board who identified that issue and would actually call out what he called tribal alert if it looked like we were going to vote along, legacy firm lines and ask us to re-examine what we were doing and whether we had some sort of bias there that we weren't, that we weren't really looking at. We learned that you can work with people even if you aren't sure what their motivation is, where they're coming from, and a lot of times it's the lack of familiarity with someone, simply that you learn that once you can overcome that and get to know those people better, they aren't bad, they don't have an evil conspiracy. They may be judging it from what they know and their own experiences, but there are ways that you can, and a lot of times it's just simply talking and getting to know people that will help with respect to that. But the next day, you're gonna have another vote, and you're gonna have to vote on that, and you're gonna have to get along. You can't become enemies with people that you're gonna be working with for years.
Mrs. Roberts? Ms. Conover?
I'm curious how much of your time your management responsibilities take, percentage-wise?
We have a billable hour requirement at our firm. I'm on the executive committee, which does day-to-day operations. I am held to the same billable hour requirement as all of my partners, and there are term limits on the time that you can serve. I could go for another term, but I've already told my board, the chairman, that I'm not interested in doing that because I want to keep my practice. I have kept my practice. I even think at the moment I am ahead of billable hour requirements for this year. We don't get paid to be on the board. It's an honor, certainly, and it's been fascinating and interesting, but were I to go on the executive committee, which wasn't something I was interested in doing, because then I think it is hard to keep your practice, then there is a reduction, I think, in expectation with respect to it. Thank you.
Mr. Bloom?
So I'm not a lawyer, so I'm not sure how well I can articulate this question, but I would guess in a very high-level successful practice like you're in, there must be times where you get frustrated with the law as written and would prefer it was improved, the language was improved. So I was wondering if you could just give me an example of an area of frustration and what you or your firm might have done to work on changing that and how it turned out.
Okay. I mean, I think one that comes to mind, I was recently involved in a telecommunications case that we ultimately appealed, we lost. The telecommunications issue, the statutes that are involved used to separate broadband, well, there wasn't broadband before, cell service, cable service, there are franchises involved. The statutes don't really work very well anymore because those are all merging together. So I don't know if I'm answering your question very well, Commissioner, but we were frustrated because we felt like the court had to apply the law the way it was, and we felt like, and again, we were advocating on behalf of our clients, so we took the position that was our client's position, but I felt like there was a way that the court could have ruled in our favor, if you would, and applied the law as it existed and interpreted it without, without us losing. But the court disagreed and we lost. I thought they basically sort of decided it doesn't really apply anymore because it doesn't work and we're just not going to go there. So that was frustrating. I don't know what we could have done other than try as hard as we could to explain a very complex case, and I think we did try, but we failed.
Well, that was a better answer than my question deserves. So.
Mr. Goodman?
Thank you.
You
First
need
of all,
to grab a microphone.
yes, thank you. First of all, I'd like to thank you for your application. We have 20 great candidates applying, some judges, some private practitioners, but I think we're very fortunate to have lawyers of your caliber who are very successful in private practice, who make the sacrifice to apply for a job like this. I think that's true with Christine Lebron-Dykeman too. You both have very sophisticated national practices, and the fact that you're willing to offer your talents to the Supreme Court is a wonderful thing. for anyone that might say during our deliberations that this is a state court, it is not a federal court, I'd like you to address the question how your background in commercial law or a sophisticated background like patent law, I know you're not a patent lawyer, but that sophisticated practice would assist the Supreme Court. And I'd like you to describe to us through a case that you have dealt with, recognizing that all statutes are in English and it doesn't matter whether it's state or federal, how you've approached a very sophisticated, nuanced problem to decipher and reach a position or conclusion.
Well, in federal court, you want me to?
In
explain?
any jurisdiction, but I'm basically asking what talent, I think you bring a rare talent to the Supreme Court because you've dealt with very complex issues. The Supreme Court deals with about 100 cases a year, and they are the most complex cases that are offered up in the state. And I think that the experience you have, even though it may be in more federal areas, would assist the Supreme Court. And I'd like you to, you know, from your experience, tell us how that's true.
Well, to the best example I could think of is, I think the first one on my application of 3 cases that I chose that were significant, which is a case actually that was in Delaware State Court. It was unbelievably complex. I mean, our heads hurt trying to figure this out. There was a person who was, we believed had committed fraud and taken money away from 2 client investor companies. And he had done this through a series of limited liability companies, and each one was a member of the next one, and had made himself, I see that might yell out quickly. We used diagrams and graphics in our complaint to show where the money went, and I admit that I had people with better technological abilities than I did to help me do that, and otherwise we'd have never been able to get anyone to break it down and follow it. So that's the one example that I can think of.
Mr. Sukup?
Thank you, Your Honor. In your, do you have any case with Judge Bright where you, with your 3 rebuttals, were you ever able to change his opinion on it?
No.
No.
And I do remember arguing with him on a Fourth Amendment search and seizure case of a car, because I said I cannot distinguish this case, Your Honor, that, you know, that's a car, automobile search, other than to say that was a Buick and this is an Oldsmobile. I mean, I don't know what to do. And he got a little annoyed with me and said, well, I'll just write it myself. And when we got to the part where we were supposed to distinguish the case, he said a note to me, Terry, flesh this out. So, no, I can't remember a time when I talked him out of it. But he did have some clerks bring some cases to him and bring it to his attention. There was a James Dean Walker case that became quite famous that went on for years. And he was convinced there was a miscarriage of justice, and he went after it, so.
Ms. Stigma?
No, thank you.
Ms. Sinclair? Mr. Bevel?
No.
Dr. Taylor?
Just a brief question. You had spoken earlier about, you know, wanting the courts to apply the law, but, you know, I'm seeing as the wife of a legislator how slowly the legislature moves and can't keep up with technology, and they're searching to create laws around technology and cannot possibly keep up. So certainly there's going to be things that come before the Supreme Court where there just is no applicable law whatsoever because X didn't exist before now. So what would your philosophy be on how the Supreme Court would address measures that come before them where there truly is no precedent or no applicable law?
Well, we can only decide issues of law. So the case would have to get to us somehow by, somebody would have had to assert a cause of action, of some type of legal cause of action. So we have to determine whether whatever it is they're arguing fits within that legal cause of action or whether it doesn't exist. I mean, the farm crisis cases that I was talking about that we handled in the 8th Circuit, farmers were arguing that the government needed to force the FMHA to make a loan. And there just simply wasn't, I mean, it was heartbreaking. And I was sitting there with people at the council table knowing my father lost his farm in the Depression, but there was no law that would require a bank to make a loan to the farmer. I mean, and in the technological case, the telecommunications case I was talking about earlier was an example where I thought maybe there was a way to wade through current law, but I was wrong on that one. It's very difficult, it's true. And we're gonna have to face it, obviously, because it's happening in every industry, especially ag. Tech is everywhere, so it's a problem.
Mr. Diaz? Mr. Berger?
Yeah, no question, Your Honor, but I have a comment for you.
You need a microphone, or I'm gonna get a text that no one could hear you.
Lance made a comment about, you know, how smart you are and everything, and after our interview, I just thoroughly enjoyed it. I wanted to do this for the committee. I found out she liked horses, and so after the interview, she jumped in her white Ford pickup truck and headed down to the Clone Sale Barn, and that's where we finished our interview during the first Monday of the month horse sale. And so I felt that not only she's very bright, but she's very well-rounded too. So I enjoyed it. Thank you for your honor.
We are out of time, but we do have time because we're running a little ahead, so if either Ms. Bowden or Ms. Pearson have a question, go ahead.
Yes, thank you. In your application, as you've spoken, majority of your practice has been civil, business-oriented matters. The Supreme Court handles a wide diversity of cases from individuals, small firms, all types of diverse matters. Is that a disadvantage to you? And if not, how are you going to overcome that if you become a justice?
I will be at a disadvantage in some of those cases to my colleagues who I hope will have greater experience on those particular matters. I will have to learn those areas of the law. Some of them I think are similar, and I ought to be able to grasp it. I've done a good deal actually of work in the criminal procedure area and also studied it in law school. So I think that's something I feel like I can grasp with respect to estate issues or family issues, juvenile issues. I will need to bone up on that. Absolutely. I'm hoping that I can in turn help to the extent that there are others on the court who have less experience in some of the areas that I do.
Thank you.
Ms. Pearson, do you have a question?
I do. When I met with you, which I very much enjoyed, one of the comments that you made in terms of your philosophy and so forth, and you kind of reiterated that today, so I really want to give this to you as a compliment, that in making decisions, or the role of the justices is to apply neutral principles until they get all of the facts. And you commented that again today, as you know, your methodology is wait till you have all the facts. Is there any one particular case or situation that you can share with us that just made a significant impact on you that you recall today and it's part of who you are?
Well, again, I have to go back to my clerking days. I mean, we had to read the entire record, and if you didn't know particular facts make a difference. They just do. I can't think of a specific case that made me want to do that, but I will tell you every time that I didn't do it, I regretted it. And if I have a weakness, it's that I don't know how some of these lawyers take an associate with them who prepares them for a deposition on their way in, and they don't really look at things themselves. I don't have that ability. I see that the light is flashing, so, oh, that's right, we already did. So I don't have a specific one.
That's fine.
But I just think that's how you have to do it.
Thank you. I think you stated it when you didn't do it, it didn't work out as well.
No, then I regretted it because I realized it might have changed how it fit within a statute or a case law that was already existing, and I would have made a different argument or told my client to settle or whatever it is they needed to do. Yeah.
Thank you.
Thank you, Ms. Combs. We appreciate it and we wish you the best of luck.